The rapidly growing field of air and space law is a bit of an oddity, widely unknown to most lawyers, let alone the general population. Montreal, however, assumes a unique position at the forefront of this field, home to the UN's International Civil Aviation Organization, as well as the Canadian Space Agency and Bombardier, the third largest aerospace manufacturer in the world. It is only natural then that Montreal should also play host to the world's premier educational and research institution in the field, the Institute of Air and Space Law, right here at McGill University. I recently sat down with the director of the institute, Dr. Jakhu, to learn more about his fascinating research and the future of international space law.
Space law is becoming very important because space is becoming important. Space matters today. You just imagine life without a satellite. It's a possibility that we may not be in a position to withdraw our money from ATM if satellite is not there, it's not working. We may not be in a position to fly because GPS may not be working. The trains may not run properly. And possibly electricity may not be there because there is failure of certain satellites. Of course, internet, television, all things will be affected if the satellites are not working properly. So we are heavily dependent on space. But we do not really realize these things now. But it is becoming important, so that's why countries are becoming interested in making sure these chaotic situations do not arise and want to make sure that space activities are carried on smoothly according to the law, according to applicable laws in that. So space matters. Because space matters, that means space law matters. So on 12th of October this year, announcement was made in Paris by a gentleman called Dr. Igor Ashabeli. He is a Russian scientist. He has the concept of setting up or initiating a new space nation. We here at McGill, I am acting as their advisor on legal side of that. So to me, it makes a lot of sense from legal point of view. Whatever we have a nation, a group of people working together, declare their independence from Earth. Eventually, they may become a state and also may become eventually member of United Nations. And once it is recognized by other nations. So it's a fascinating idea, and we are very proud to be part of this new concept which is developed. This guy is visionary, and I'm sure he is dedicated, and we are providing them legal help with respect to the laws and regulations which they need to follow now, and also eventually we may be drafting their code of conduct for people, those who will be living there. So we may be involved in the design of legal system for these people living in space. There's a microgravity in space. It's a unique environment which could be used for manufacturing certain things which we cannot do it on Earth. You mentioned about Elon Musk is going to Mars, colonization of area, and mining of asteroids. You're talking not millions or billions of dollars, you're talking about trillions of dollars to be made. So it is becoming very important, and some companies are going to have space tourists. You're going there, you may go for honeymoon or maybe have a breakfast somewhere and come back for lunch. In 15 years, people will be flying from Montreal to Tokyo in 2 hours. Those things are not part of science fiction, and they are going to be fact. They are becoming fact today, and they will become fact in very near future. So because of the involvement of private industry, activities are increasing, and that gives the rationale for development of law. Here in the institute, we are very much advanced in thinking ahead of our time, and we are carrying on a number of very highly innovative projects in space law. So maintain our relevance and doing innovative work in this area. And I repeat what I said, the McGill Institute of Air and Space Law is world leader in space law. So when I did my master's here at McGill in 1978, so I was thinking of doing PhD in law. So that I thought, hey, this is an interesting area. Nobody has done much work in that area. So I decided to do my PhD. I'm a DCL, we call Doctor of Civil Law, here in 1978. So I finished my DCL in 1983. And at that time, it was considered to be some crazy idea to do PhD in space law. But I knew that the things are going to develop that way. So we never study for yesterday, neither for today. We always study for future. So it was my thought, this is the area which is going to be very important and is going to be, will have an impact on our civilization, lives of people, lives of nations. So that's why it has been a very interesting journey. And today, I will say, nowadays it's really very, very interesting field of law. While space is a very complex, it's expensive to go to space, but it's also highly political, strategic importance. And because of this strategic importance, including military uses of space, countries are not willing to cooperate with each other because they want to maintain their sovereignty or their own way of doing things. So they are not readily accepting the views of others. So that's why international regimes are not forthcoming that often that should be. But in the early 70s, 5 treaties were adopted internationally. It was a relatively calm period from international politics. I shouldn't say calm, but at least the area interesting. And the countries got together, they established 5 treaties. But after that, there's no much development in space law, binding space law. But things are getting inadequate. International regime which was created is becoming inadequate and outdated. So there's certainly need for renewal of that regime. There were no concrete rules before US went to moon, but during the Cold War period, there was a need for some cooperation. So it is out of necessity the Soviet Union and the United States got together and they thought it is a new environment, space is going to be a new environment. So they came up with some understanding and then that understanding became the first treaty, which is called Outer Space Treaty. Other nations like Canada and developing countries also felt the need for regime of that nature, which is more cooperative in nature. So it was out of necessity these 2 countries got together and set up basic rules for that. These are mainly principles. They're not detailed rules as such, but they say principles. So the countries set up fundamentals. For example, space should be used essentially for peaceful purposes. That does not exclude military, but peaceful purposes. Secondly, nobody should go and control space. So appropriation of outer space and celestial bodies is prohibited. The third was that private companies may be allowed, but the government remains responsible for the damage if it's caused by private sector. So those are the fundamental rules. And also, I will say, freedom of outer space was recognized, that all nations are free to use outer space, explore outer space on the basis of equality without discrimination of any kind. In international law will be respected. So those fundamental rules were accepted as understanding between the 2 nations, and then they became part of the international regime incorporated into 1967 Outer Space Treaty. Well, private companies are becoming very important and they're active in that. They have good amount of money, but we should also see that most of these companies are dependent on government contracts. So they are putting up their own money, but also most of the work which research and development has been funded by the governments. And of course, the further development, refinement of those technology, development of new technology, development of new applications is being pursued by private companies. So the governments are active in certain parts of the world, for example, India and China, to some extent Russia. The governments are still very, very active. In Canada, United States, the governments are kind of withdrawing from this field in a sort of providing help to the private sector. The private sector is taking the lead in that. The thing is, no private company can go to space on its own. Private companies need a license from their respective governments. Mr. Musk is going to Mars, but it needs the permission of the US government. His company, which needs a license from the US government and also should remain subject to US supervision on that. So private companies are not prohibited to go to space, but they have no choice but to go through their government, through the government authorization for any kind of space activities in the world. Well, my view is that private companies should be allowed, encouraged to go exploration and exploitation of outer space, but remain subject to the authorization of their governments. The governments are responsible internationally, so private companies are not internationally responsible, but their governments are. I think the government supervision is very important in that way. Take the example of some kind of safety precautions, safety standards need to be followed. It's the governments can impose or should impose on the private companies so that the overall damage to Earth and space environment does not take place in that way. So the government's role may not be important to provide money, but the role of the government as regulators must remain. As a matter of fact, I would say it should become even more rigid on private companies. Well, the private companies, if they declare that particular asteroid or particular area of outer space belongs to them, so that will be violation of international law because international prohibits appropriation of outer space and celestial bodies. Now, keep in mind, it is not the private companies which are violating international law. It is their governments will be considered to be violation of international law.
You mentioned the use of celestial bodies. I read the article the CBC article, where back in November 2015, after President Obama signed legislation providing a framework for U.S. space companies to mine ore from asteroids, you claimed in the article that the act was a violation of the 1967 Outer Space Treaty, which prohibited the commercial harvesting and national appropriation of celestial bodies. Why was there such controversy among legal scholars about this issue if the treaty, which was signed by the US, Canada, and a number of other space-capable countries, pretty clearly spells out that there shouldn't be any private property rights in outer space?
Well, one thing is that the legislation adopted by US in November last year is designed in such a way that it can provide private ownership to the private companies. So that means the private companies can own and also appropriate certain areas. And that means that will put the US government in violation of its international obligations. So that is why there's a hue and cry against sort of allowing private companies to appropriate outer space or celestial bodies.
Why was there the controversy among legal scholars on that particular issue?
Right. The legal scholars were divided and still are divided. Some people believe that act is not in violation of Outer Space Treaty. The others say, yes, it is in violation of Outer Space Treaty. The scholars, those who believe that US Act is not in violation of Outer Space Treaty, put forward the argument that this treaty, 1967 Outer Space Treaty, prohibits the appropriation of planets, but it does not prohibit the appropriation of resources underneath. But the other side say no, the treaty prohibits both the service of these planets and also the resources. So that is the main controversy.
The particular term used was celestial bodies.
That's right.
In the treaties. Celestial bodies, is that defined as, does that include asteroids under its framework as well?
That's correct. It doesn't matter what the size of the asteroids, meteoroids, planets like Moon or Mars, they're all covered in celestial bodies.
Okay. Yeah, because I'm interested in, I guess, the relationship between how the changing terminology used by astronomers on the one hand versus the legal mechanism of how you define them. Considering, like, in the example of Pluto, one day to the next, we can change the scientific classification of a celestial body. How does sort of the legal side of that respond?
Well, that's a very interesting question. But again, rules of interpretation of treaties is that you should look at the common meaning of a term. The celestial bodies today, which is defined in mainly credible dictionaries, the dictionaries include, asteroids or celestial bodies include asteroids, meteoroids, comet, planets. So that is the meaning of celestial bodies. Now, the governments may specifically define celestial bodies differently. later on. But that is the current meaning of celestial body, is that it's comprehensive and it includes everything, irrespective of what the scientists think.
What is the enforcement mechanism behind this treaty, as well as other similar ones that have been passed?
Well, in international law, there's generally no enforcement mechanism. And certainly in space law, there's no enforcement mechanism. The countries are required to fulfill their international obligation in good faith. So there's assumption the states, the countries are civilized countries, they believe in rule of law, they must follow the rule. Normally, I will say international law is followed. We send a letter from one country to another country, it goes to the other country. I send an email from here to other part of the world, it goes there. And there are international rules which are followed. We fly from one place to another fly. International law is followed. I'm saying mostly international law is followed without any enforcement mechanism. So assumption in this case also that the countries will follow international law, and that's essentially because it is in their interest, and also that there may be political backlash on those who do not follow the law.
They're voluntarily tying their hands in a way so that it increases the public trust amongst other nation states.
That's correct.
At an international level.
Absolutely. The countries do not want to be blamed, particularly in the United Nations, that they are in violation of international law. There's a political price to be paid for those states which are violating. We have direct and indirect role. Indirect role is that we train people, those who are specialists in space law, national and international law. We hold conferences, we address these issues. People from other parts of the world come and attend that. And we conduct research on certain issues. We recommend certain things which need to be taken care of when the treaties are adopted, and that's indirect. I think that our influence is mainly indirect, but there is also possible direct influence because staff members or faculty members of the institute are invited to draft legislation, particularly national legislation in different countries. I have been invited into India and South Africa and even in Canada, and my other colleagues are invited in other countries where we draft legislation laws for them. Of course, this is we play an advisory role, but it is to a good extent, I think that is a direct participation in the formulation of law.